We're live.
Okay, we'll call this meeting to order. We have our corporations meeting for Friday, February 13th. And we'll have three bills to cover today. HB 92, HB 140, and HB 144. Glad to see the room is full. I hope there's not a fire anywhere.
Sorry, I was talking to
Oh,
a
you're fine.
constituent.
You're fine. We just started. Please call for attendance.
Representative Brown,
Present.
Representative Locke,
Present.
Representative Heft,
Here.
Representative Johnson,
Present.
Representative Lucas, Representative Webb,
Here.
Representative Weber. Here. Representative Yin,
Here.
Chairman Knapp.
Here.
Mr. Chairman, you have a quorum.
Thank you. All right, first bill up is House Bill 92. And since you got settled, we'll have you, and you can present from your seat or you can present on the dais. We'll have Representative Lucas present this one. It's sexual predators prohibited from public office. Representative Lucas, when you're ready, you can just go ahead.
Thank you, Mr. Chairman. My colleagues, members of the committee, thank you for your kind attention. I wanted to sit here because I don't get to look at you face to face when we are in committee, so what a pleasure. I bring to you today House Bill 92. And I wanted to tell you just for a moment why I ran this bill, why I created this bill. I live here in the county that this Capitol building resides in. In 2024, a man listed on the Wyoming Sex Offender Registry ran for the board of a community college here. And he had been convicted twice of sexual abuse of a minor and was required to be on the sex offenders registry and was. Our current law does not clearly prevent this from happening and does not prevent these folks from seeking public office. Public outcry did convince him to withdraw from that race, but we realized that we had a serious gap in Wyoming statute. Public office is a position of trust, authority, and access. It involves influence over policy, budgets, personnel, and critically, direct and indirect access to children in vulnerable populations. I can't tell you how many schools I go and visit, how many vulnerable groups I meet with in the course of doing my job. Many of the offices covered by this bill routinely operate in places where children are present. School board members, community college trustees visit schools and campuses, attend events, and oversee institutions that serve minors. Mayors, council members, county commissioners, prosecutors, and sheriffs regularly enter school, participate in youth programs, community facilities as part of their official duties. House Bill 92 establishes a clear qualification standard. A person who is required to register as a sex offender is not eligible to be a candidate for, appointed to, or serve in certain sensitive public offices. This bill does not create new crimes. It does not increase sentences. It does not relitigate convictions. It simply recognizes that some offenses, especially sexual crimes against minors, are so serious that they permanently disqualify an individual from some positions of public trust. I say some because I was not able to include many of the elected positions in Wyoming, including our own, because our eligibility is dictated by the Constitution of Wyoming, as it is for the top 5 elected offices and those elected to the other house of the legislature. So look for, at some point, I just think we're doing a lot of constitutional amending right now, and maybe let's wait a minute for that amendment. This bill also preserves due process. If the court or the governor expressly restores eligibility to hold public office, that authority already exists. So if somebody is adjudicated to not have to be on a sex offenders registry, then they would be eligible, provided that they're an acceptable elector. At its core, House Bill 92 is about protecting children, protecting the public, and ensuring that Wyoming's institutions remain worthy of the trust that parents place in them every day. I'd like to walk you through the a bill if that's all right. It's not a very long one.
Yes, please.
Okay. So this is a new statute and is created to read qualifications for office, ineligibility of candidates convicted of certain sexual offenses. Page 2, those offices include trustee of a school district, community college district board member, county attorney or district attorney, county commissioner, member of the governing body of a city or town, mayor of a city or town, county sheriff. Page 2, item B, the Secretary of State, the county clerk, or other appropriate election official shall refuse to certify a candidate's name if that candidate is ineligible to hold office under this section. That person is then disqualified from office under this section, and that position, if it's already filled, shall be deemed vacant. As used in this section, a sex offender, in quotes, means a person who is or has been required to register as a sex offender pursuant to Wyoming Statute 7-19-302, regardless of whether that registration has expired or been terminated. Sex offender includes a person required to register as a sex offender who has had civil or political rights restored unless a court of competent jurisdiction or the governor expressly restored eligibility to hold public office. I'm asking for this to be effective on July 1st of this year, and I would answer your questions. Thank you.
Thank you, Representative Lucas. Questions? Minority Leader Yin.
Mr. Chairman, thank you. So Representative Lucas, it's not a lot of work for a clerk to do this. Of course, it's, you just check a registry. I'm curious, do you think that, and you did say that someone tried to run for office, do you think someone would ever actually win public office while being on the registered sex offender list? I think no one would find that acceptable anyways, so they would always lose. So do you think we're protecting against something that would probably not happen?
Representative Lucas.
Thank you, Mr. Chairman. Minority Floor Leader Yin, that's a great question. However, I believe that information, whether somebody is on a sex offenders list, is not always apparent. Most of us don't go to those lists just, every time we see a candidate for office. That's not my first thought. Well, I don't know. Is he on the sex offenders list? We don't think like that. So when this actually happened, somebody did register to run for public office. I think that it was an accidental situation where this person was found out to be, and then it became public. No, probably if it were known, that person would not be elected, but I don't know that it's always public.
Follow up? Any other questions? I just had one. Last year we had the sex offender registry revised. And so I want to be clear. I think you kind of spelled it out, but there are lesser degrees that can petition to file to get off the registry. If somebody did get off the registry, this would still apply to them, or would that then expunge them from this bill as well?
according to the way it's written, we may want to look at that. It does not say that they are not
Okay.
still prohibited, but,
I think
yeah,
just
I think
something
we
to
might need to
look
talk about
at,
that one. Yeah,
only because I know the bill last year took the most severe or with the child or things like that. But there are one level of at least registry that you can still petition to get off after a certain period of time. So
yeah.
that might be something to look at and just make clear.
Thank you,
I
sir.
think
Also, just to comment on that too, this isn't just about crimes, sex crimes against children. It is any kind of sex crime. So this would also preclude rapists who are required to register on the offenders list also.
those more
which-
severe. Yes.
Yeah, exactly.
Okay. Any other questions? All right. Thank you.
Thank you.
All right. Are there any agencies that are here to testify on this bill? If there are. Sure. Yeah. Any other people in the public that wish to testify on this particular bill? Yes, please identify yourself. We'll go ahead and start here and then we'll let everybody else that's coming up to speak. Okay.
Thank you. My name is Dallas Terrell, and I just want to thank you all for the time, the chance to speak today. I want to just echo what Ms. Lucas said. In 2024, we had a situation here in Laramie County where a person who was had pleaded guilty to felony sexual exploitation of a child in 2002, and for decades had been barred from being within 1,000 feet of a school here in Wyoming. Registered, filed to run for a school board position. The thing that I think was so alarming about this is had he won the position, he would then be allowed to be on school property, and not just one school, all schools. I believe it was a calculated effort on his behalf to try and get back back around young children. So that is why this is so important. I think that Ann Lucas brought this, so important that we bring light to this issue today. And I'll pass it down.
And then I'm sorry, I might have missed it, but did you identify yourself at the beginning?
Yes,
Okay,
I'm Dallas
thank-
Terrell.
Oh,
Yes.
Dallas.
Thank
yes.
you.
Sorry. All right, next.
Good afternoon. Chairman, my name is Lynn Story Heiler. And in my professional career, I'm the director of Safe Harbor, a Children's Justice Center. We are a child advocacy center, and I'm a certified forensic interviewer of children. So I'm the person that talks to these children about this bad stuff that happens to them. In fact, I apologize today. I don't look very professional because I interviewed 3 children this morning. So I needed to be in attire more fitting for that. So I can talk on behalf of victims and how this affects victims, but I also was on Laramie County School District Number 1's Board of Trustees for 8 years. So I was an elected school board member, and I can talk to how you are seen as a school board member, as a person of authority. It's a great weight upon you. However, people do look at you as having that ultimate authority. You are the boss of the school district. You are in that power of authority, and children also see you as having that power of authority. What happens when you're a school member? You go into schools a lot. I was in numerous classrooms. I was in activities. I was at performances. I was where children were. And to think that we would allow someone who has harmed a child, has been identified through the court system as harming a child back in where children are is pretty concerning to me as a forensic interviewer and as a school board member. Children are our most vulnerable resource. We have to protect them. They don't have the ability to protect themselves. 94% of children who disclose abuse, it's delayed. Children don't come forward immediately to say that something bad has happened. So when you're around these people, we might have lots of victims who never come forward. So that's why it's our job or your job to protect children from people that may want to go. The other thing that we know about perpetrators, they go where the children are. That's where they want to go. And so allowing them to go there, we're not doing our job to protect children. So I would ask you this from a school board member, past school board member, and then an advocate of children who interviews children day after day after day. Please consider this. We need to protect our children. So thank
Right.
you.
And thank you for your service on the
Thank you.
board too. All right, next.
Good afternoon. My name is Caleb Wilkins. I apologize. My voice is a little rough here today. Tail end of that cold that went through town. I wanted to come here today to support my friend Dallas Terrell. We had worked together on the situation he had discussed. Wyoming statutory framework I believe has what I would describe as a loophole. Many of us would describe as a loophole. In essence, Wyoming statute, I believe it's 610-106, prohibits certain individuals from being qualified or running for office. A felon cannot hold office of honor or trust or profit unless rights are restored, pursuant to 713-105. Generally speaking, there's a large loophole in 1713-105 that would allow an individual who has committed nonviolent felonies to have their rights restored. Now, I'm not here to say that individuals cannot turn their life around. Unfortunately, as we've heard, the numbers don't look good in this specific context. But here, there are certain instances where we're pitting the rights of innocent children against convicted violent felon or nonviolent felony offenders. I'm going to go with children every time, and I think everyone in this room would. Our problem is, under our definition of violent felony pursuant to Wyoming 61104, it actually specifically excludes. So everything in the law, I'm a lawyer for sake of full disclosure, so we lawyers love to phrase everything in the negative twice so it makes no sense. So what I'm going to do is read to you a couple of the offenses here that are nonviolent for the purposes of having rights restored. For example, 62314, sexual abuse of a minor in the first degree. Sounds terrible, and it is. An actor commits the crime of sexual abuse of a minor in the first degree if Part A is considered violent. Part B, I'm about to read, is not. Being 18 years of age or older, the actor inflicts sexual intrusion upon a victim who is less than 18, and the actor is the victim's legal guardian or another individual. Part 3 is essentially the same thing, and it says the bad actor occupies a position of authority. Now, if we go on to 62315, abuse of a minor in the second degree, or 316 in the third degree, we'll see a common theme. These offenses almost always involve position of authority. And some of these defenses they're all bad. There are some that just are difficult to read. For example, 62315 is not considered, A1 is not considered violent, but it's being an individual who is 17 years of age or older, so an individual who could be 35, that inflicts sexual intrusion on a victim who is 13 to 15 years of age, and the victim is at least 4 years younger. Here in Wyoming, we don't sugarcoat those sort of things. That could allow a 35-year-old to rape a 13-year-old, and it's nonviolent. So
I'm sorry, I had one question. So would you advocate, in the question that I had asked before, would you advocate for anybody who has been on the registry, whether they've been petitioned to come off the registry or not, to be included in the bill?
thank you for the question, Mr. Chairman. As the bill is written, I understand it to allow those who've been removed from the registry to be eligible to run for office. I have candidly not put a ton of thought into that because there's a lot of nuances in this area of law. I think this is a meaningful step forward that would have blocked any of the instances we have known about. There's been a few. Actually, turning to Representative Yin's question, which I thought was quite astute, sir. Is this a solution in search of a problem? I know it is not. There's a number of individuals we've identified. I will not use their names here today for their sake. But I will say most of these races that are in question are races where there are more than one available seat and there's a multiplicity of candidates. I believe there were 2 or 3 openings in the specific instance we were referencing and 7 available candidates. We didn't learn that this individual was on the list until very late in the race. And I do believe that in today's world, if you have enough open seats and enough candidates, someone, even if they're known to be on the list, could still very well win. I don't think that's a risk we could take. So I believe the answer to the question is yes, there's a very real practical risk. So thank you for that question, sir. With this in mind, I guess I'm just going to respectfully submit to this body that this is a loophole in the law that we need to close, because we shouldn't allow a 35-year-old who's raped a 13-year-old to run a school board and be in a position of trust. Thank you for
Thank
your
you.
time.
All right. Next.
Mr. Chairman, through you. My name is Taft Love, current Senate District 6 representative. 10-year school board member in District 2. Had a little bit to do with party politics in between and then here. I was involved in this with Mr. Terrell and Mr. Wilkins. Firsthand information, Dallas Terrell was the one who found this and brought it to everybody's attention. We then made everybody aware of it and tried to make corrections at the time. I'm just here in support of this bill. We ban so many things from the institutions that protect our children, including guns and cigarettes and drugs, and why in the world we would ever let a sex offender on a campus, I have no idea. So I'm here for support of this bill.
All right, thank you. And Senator, welcome to the committee, first of all, and I apologize for not introducing you before sooner. So thank you, Senator Love. All right, are there any questions from the committee for any of the four presenters? All right, thank you very much. We appreciate it. Okay, anybody else can fill the seats? If not, Kathy, please introduce yourself and go ahead.
Thank you, Mr. Chairman. Kathy Russell, Executive Director of the Wyoming Republican Party. I'm here to share what the stance is on this kind of issue. I'm happy to see this bill. I would say the party would be happy to see this bill. The basis of the U.S. Constitution is protection of rights. The platform of the Wyoming Republican Party are principles that we believe should govern the law, and that is to, in this particular case, it would be to protect the innocent, address recompense and redress of crimes, and then to prevent a future infraction. This particular issue, for the reasons that you have heard already, needs to be addressed. This is a good first step. In the recent past, we have had a shift in our culture to protect the one who is being under justice, the perpetrator. We need to shift that culture back to protect the innocent, and especially our children who cannot protect themselves against an adult. We need to recognize that protection of the innocent is primary in our culture and adjust the civil code of conduct. This is a good first step. Thank you.
Thank you, Ms. Russell. Any questions from the committee? No? Seeing none. Is there anybody else in the public that wishes to testify? I know we did not have anybody online. Is there anybody that's come in?
No, Mr. Chairman.
Okay. All right, then I will close public testimony. Committee, what's your pleasure? It's been moved and seconded to move the bill. Are there any amendments to the bill? Yes, Minority Leader Yin.
Mr. Chairman, thank you. So I do think it will be harder to administer if because reading it on page 3 in that section C, basically says anyone who has ever been on the list, regardless of if they're currently in the list or not. So it's really up to the committee on whether it wants to make that broader, but on the administration side, I'm curious on how we would enforce that, right? Does the county clerk have to look up, or the town clerk have to look up? And how do they do that? And we actually don't have that information in front of us.
All right. Representative Lucas, do you have at least a comment or an answer to that question?
I'm kind of torn on this one, but I understand logistically how difficult that would be to work. I'm puzzling in my mind. How would that work if I were administering an election and accepting applications? If somebody is currently on a sex offenders list, that's easy enough to determine. It's easy enough to determine tiers, which to my mind, if you're on a sex offenders list, it really doesn't matter how lightly you sexually offended somebody or how seriously the injury was done. But I'm unsure that we would be able to detect a prior offender who is not currently on the national or local sex offenders list. I just don't know how we would do that.
You know, one thing I would think of is there's still a criminal list that you could, if anybody's ever been convicted of a sexual crime, then you wouldn't necessarily have to look and see if they're on the offender list. You would just see what their conviction was, and if they've been convicted, they're on the list, required to be on there. So even if they've been expunged, their criminal record would still exist.
Mr. Chairman,
Yes.
so maybe for now, again, this amendment will have to, I'm going to offer an amendment, and even if we adopt it, we're still going to have to discuss it on the floor, but hopefully we'd actually have information on how to administer it. So I'm going to offer an amendment that would make it so we only do people that are currently on the list, and then we can debate on the floor if we have information of what that actually looks like. So the amendment that I have is on page 3, starting on line 5. After the word who, after person who is, insert currently in the registry defined in 719-303. And then strike the rest of the paragraph. And I believe that covers that. So that's the motion.
All right. Is there a second? It's been moved and seconded for the amendment. All those in favor, please signify by saying aye. All those opposed, no.
No.
Okay, that amendment carries. And again, I think if we wish to look at this for committee of the whole, if you can do a little more research before then, it might make sense to work on an amendment during that time. So,
Mr. Chairman, could I
yes,
have that statutory reference repeated.
Representative Yin.
Mr. Chairman, thank you. It is page 3, line 5. It would read person who is currently in the registry defined in 719-303. And then the rest of the paragraph would be stricken.
Thank you, Mr. Chairman, Representative Yin.
All right. And to those who testified, if you do have information that could help with that for committee of the whole, please feel free to contact Representative Lucas. So, all right. Any other amendments? Question's been called. Please pull the board.
Mr. Chairman, there's a roll call vote for House Bill 92. Representative Brown,
Aye.
Representative Locke,
Aye.
Representative Heft.
Aye.
Representative Johnson,
Aye.
Representative Lucas,
Aye.
Representative Webb,
Aye.
Representative Weber. Aye. Representative Yin,
Aye.
Chairman Knapp.
Aye.
Mr. Chairman, you have 9 aye.
All right. The bill is approved through committee. Thank you, Representative Lucas.
Thank you.
Next up, we'll have House Bill 140. This is construction inspections, qualified third parties. Representative Filer. Good to see you twice in one day.
Thank you, Mr.
3
Chairman.
times.
Mr. Chairman, members of the committee, my name is Lee Filer, House District 44 here in Cheyenne. Earlier today, had another bill in another committee that set guidelines and standards on how we can get building permits quicker for residential. Right now, we're having a hard time in certain areas of the state that we're having a housing shortage. Many developers are running into a lot of excess costs and everything when it comes to developing. So at the end, it usually ends up being more pushed onto the consumer at the end of a build. So we're trying to find ways right now of being able to streamline these red tape and bureaucracies within municipalities and building departments in order to make sure that we can have developers get through the process quicker and speed the market. And the old saying is time is money. So with that, Mr. Chairman, I bring you House Bill 140, and this is third-party building inspections. And that's what it does is it creates a path where a developer, after they pull their permits, do everything with a building department, usually you have to schedule all your inspections for your building project through that department, through that municipality, that building department. Well, what happens is a lot of times is when you're building with our wonderful building season in Wyoming, which this year's been really good. Usually we're not building stuff right now this time of year, but what happens is a lot of times that the building inspectors, one, could be overwhelmed, have a lot of inspections ahead of you, which sets you back. So kind of the analogy I've always used is, hey, I need rebar inspected on Friday because I need to pour on Monday. And if the building inspector says, well, I can't get to you till Wednesday, well, now your project is delayed again. So what this does is allows the builder to work with the municipality or the building department to hire a third-party inspection. A third-party inspector, which would be an architect licensed under Title 33, a professional engineer that's licensed under Title 33, and also a certified international code counsel, somebody that's certified by them, or somebody that's certified by the local authority in order to do these inspections. There's accountability within this piece of legislation. Also, if you looked on page 3, Part A, so the accountability measure is to where the builder can't just hire any third-party inspector. It has to be a person who has not prepared, stamped, signed, or professionally responsible for the plans specifically to the work being inspected. So me as a builder on some of my stuff, I couldn't hire the same engineer to come do a third-party inspection that drew the plans. It has to be somebody totally separate from that, so there's no conflict of interest. Also, the other part of that too is the municipalities, as we know, when you pull a building permit, you pay a cost for that. And part of that fee is your inspections. But again, sometimes time is money. So if we looked on page 4, the first paragraph there, B, this would be at the owner's expense. So the person that does pull the permit, they would have to pay for the third-party inspection. It would not come out of the municipality or county's building department budget. So it'd be up to the developer to pay for that out of their own pocket. Also, it was brought up to me too, and I was trying to get all the sideboards on this to make sure everything was covered. But that third-party inspector also needs to hold the insurance policies that everybody else does with $1 million per claim. That way, the liability falls on that third-party inspector, not the municipality, but at least under our statutes, we require them to have that insurance policy. So that way they are insured, they are certified, they are good to perform these inspections. Also on page 7, we are not gonna allow a third-party inspector to do the inspection for the certificate of occupancy. That's the final inspection before like you get the key to open the door in the house and be able to live in it. So the certified or certificate of occupancy shall only be issued by the local enforcement authority. So we're leaving that authority to that local building department. That way it just a little bit more of accountability that, hey, we're going to use these third-party inspections on some stuff. And it also the builder at this whole time can still just use the municipality's building inspections if their schedule allows. Why pay a third-party inspector to come out, But it just opens it up because there is certain times a year, whether it's around the holidays or any time that there is multiple holidays within an area. As we know, municipalities aren't at work those days too. This would allow those builders also to be able to hire a third-party inspection to keep their project moving, because some of us still work on Columbus Day. Maybe a municipality doesn't. But as we go through that first part of that, so pages 1 through 7 is all about municipalities. When you start on page 8, wait a minute, not page 8, sorry. Did I lose it here? Oh, yes. So at the bottom of page 7 is third-party building permit inspections with counties. So the first part of the bill is city, second part of the bill is county, same, it's identical on both sides. So that way, if your building department's in the county, it's the same as if it's in the city. And I'll answer any questions, Mr. Chairman.
All right. Yes, Representative Brown.
Thank you, Representative Filer, for being here, and I would ask, when you're talking about that the payments would go directly to this inspector, correct? You're not going through the municipality where they're building.
Representative.
Mr. Chairman, Representative Brown, you're absolutely correct. This should be the cost and burden should be on the developer for this, not the municipality.
Representative Webb. Oh, I'm sorry, follow up.
Thank you, Mr. Chairman. Representative, the next thing that I'm a little bit concerned about is that going with just the minimums, I would feel it'd be more important that they have continuity with the municipality that they're dealing with, so that when a builder in that area already has an idea what they're supposed to be doing, that it would continue to be the same, so that there's no problems between that inspector and the municipality.
Representative.
Mr. Chairman, Representative Brown, you're absolutely right. And that is why in this bill, it allows for both. And it has to have a constant communication between both the inspector and the municipalities. So it actually has written notice in subsection C. This section shall identify the name of the third-party inspector inspections or inspections that the third-party inspector will perform. The written notice required under the subsection C of this section may be delivered by electronic means, which means that the third-party inspector does have to keep in at least electronic means, email, vice versa, or on a electronic online permitting process. So that way the municipality knows who's doing the inspections and so on and so forth. But it also allows, you can inside this bill too, at the time you pull the permit, you can actually let the municipality know that we're going to use third-party inspections throughout the whole process. So it gives the developer a lot more flexibility. Also, it gives the flexibility to the municipality too, if they are backlogged or overloaded, to where they don't have to hire more people to, especially if there's a certain area booming. This allows everybody to just keep moving fluently. But it does allow for both of those, Representative Brown.
Follow up, Representative Brown.
Not for now.
All right, Representative Johnson.
Thank you, Mr. Chairman. Thank you, Representative Filer. I was a contractor too, and I know how difficult this situation is. What if you were building a whole development? Would you be able to hire a crew of inspectors to just take care of your development? I think that's ultimately that's what could happen with this bill. And let me know what you think of that.
Representative Filer.
Mr. Chairman, thank you. And Representative Johnson, no. Because you have to hire a third-party inspector that is not attached to your project. That means they had no involvement within building plans, planning, design, or anything like that. They have to be completely separate of that. So that way they have there's no conflict of interest in that realm. Could you hire a engineer firm to do your inspections? Sure. But they cannot be attached to the project prior to this, so there's no conflict of interest.
All right, Representative Webb.
Thank you, Mr. Chairman. Thank you, Representative Filer. I'm concerned about cost. You say time is money. And so I'm in a bind, and this third-party inspector knows I'm in a bind. And can he just, you want this inspected? Good. $3,000 and what would have been $100 inspection or whatever it is. That's number one. The other one is this just a good way to pay your buddy? And those are the two things that concern me.
Representative Filer.
Mr. Chairman, thank you. And Representative Webb, I totally understand your sentiments there in your statements. with the laws and the statutes, when you have if you're a certified engineer or architect, that is your license. As far as paying your buddy, I don't know if anybody's willing to put their license and their livelihood on just for hey, you know, I'm just going to stamp this for approval and be okay with that. And it also allows within the bill, the municipality to overcheck those. So they can actually take and look at the paperwork. And also when they do the certificate of occupancy, they're able to look at those things also to make sure there's a check and balance there. And then when we talk about costs, you're right, time is money. And in the construction world, I see a $3,000 inspection, but being able to have not overpay for crews sitting there doing nothing but waiting on an inspection will cost you a lot more than that sometimes. So I think it allows the developer to decide what's the most cost-effective way for them to run their project and not let the government decide that.
Yes, follow up.
Thank you. Would you be open to having a cap set on there that it could be no more than what the city charges? The flip side of that could be, would the city then turn around and try to make money? So,
Representative Filer.
Mr. Chairman, Representative Webb, good question. No, I would not be in favor of that. The reason why is there's sometimes you could pull a permit for a house and the inspections to the municipality could cost the municipality more than what your actual permit was. So if we tie this to strictly what are those costs, like how many times they're going to have to come out, we don't know those exact costs, what they might be. So no, I wouldn't be in favor of mandating that, especially on the private market side of mandating what they can and cannot charge.
All right, we're going to go to Minority Leader Yin and then Vice Chairman Locke.
Mr. Speaker, thank you. Representative Filer, you know, we do have lots of things in place to make sure that inspector or people who have architect certifications, et cetera, are held up to a high standard. But if the municipality knows that someone is giving basically substandard inspections and they have to correct them over and over and over again at the final inspection, is there a way to, I mean, normally I assume we would have like some sort of licensure board that could be reported to, but I'm not sure if that really exists in this case. Is there a way to keep someone from being a third-party inspector anymore?
And I'll follow up with just a question to add on to that, if you don't mind, Minority Leader Yin. I'd be interested to hear from you, the municipalities, when we call for them. Could there be a pre-approved list of qualified inspectors that the city could have, or at least acknowledge, so that there is some A, continuity, and B, accountability?
Mr. Chairman, Representative Yin, and with both of your guys' comments, yes. There's actually a way in here that the municipalities, the building department can write their own rules on this. So that way that they can do that, whether it's, you know, these are certified. We know that these guys do the inspections. We know they're good. There's always those checks and balances, and that's within here too. The municipalities are allowed to write those rules in the building departments.
Okay. Minority Leader, any follow-up? Sorry to piggyback on your question there. All right, Vice Chairman Locke.
Thank you, Mr. Chairman. I think that probably covered it, but just the part that struck me was on page 3, the word "or" on line 8, right? And I think that's directly related to the two questions you asked, but that's, I think, one of the issues, just to where that approved list is available so it's clear. So just wanted to throw that out, but thank you.
One moment. I'm going to have the answer to that question first, and then Representative Brown will be next. About the question of
Let me
on
make
page.
clear. It feels like it's an "or" for the local certification. And that's the piece that it kind of struck me that maybe that should be an "and," but that's the question I'm asking. Sorry, I wasn't very clear.
Mr. Chairman and Representative Locke, I think what we're looking at, this is the professional licensing side part of it under Title 33 and Chapter 29 of the Wyoming statutes, right? So they're already regulated pretty heavily to have that license. And then it says, or a certified or a person certified by the International Code Council or the local government enforcement authority who performs building permit inspections and who meets the additional qualification standards adopted by the local enforcement authority. You know, so I don't think the or thing, if we want to take that out and say, you know, you got to be registered with your municipality, that's fine. And the building department, I have no heartburn with that. But I thought I was trying to cover all that in that one. I just was like, this one, this one, this one, but if we need to say and, sure, because I think most building departments are going to build a list anyway, but if we want to put it in there, that's fine with me, Representative.
Vice Chairman, follow up. Okay, Representative Brown.
Thank you, Mr. Chairman. Representative Filer, the one thing that bothers me here is you were saying that once this inspector was on the job, he would follow that all the way through. That's a little bit of a problem for me. Also, it sounded like you said, and I may be wrong, that you said that that inspector would be responsible. I have a problem with that. I think even though the inspector is doing the job, the municipality should be responsible. That would put them in the position of oversight. The municipality overseeing that independent inspector.
That is in the form of a question. Let's just pretend. Representative Filer.
Thanks, Mr. Chairman. Representative Brown, I think you're having some heartburn on that. I think, you know, that maybe you're reading into this as I'm going to hire a third-party inspector. They're going to go the whole way through. You have a problem with that.
A little bit.
But this bill allows for both. You can do it just for this. Like I need the rebar inspected because I got to have concrete tomorrow. You can have it just for that. As far as the third-party inspector the whole way through, if you notify the municipality at the time of permit, which is in this bill, that you are going to use a third-party inspector the whole way through, you must give that notification. And that municipality, it will not, the liability will not fall under the municipality. It'll fall under that third-party inspector. We're taking the liability away from the municipality at that time, so we're not putting them in a bind. That's why we have to have the insurance requirements also for the inspectors.
And just a clarification on that too, the city would still have the CO over their heads for accountability purposes.
Yes, Mr. Chairman, as a matter of fact, the third-party inspector cannot in this bill do the certificate of occupancy inspection. That's just your final inspection. The municipality must do that.
Thank you. Follow up, Representative Brown.
Yes, thank you, Mr. Chairman. And this is where I have the problem. Because the municipality sets the rules for building. And so I feel that the municipality should be the one that is responsible if there's a problem. And so would you be open to somehow amending this in the bill that the municipality would ultimately be responsible for making sure that those inspectors are doing their job?
Representative Filer.
Mr. Chairman, Representative Brown, I think that's already spelled out in the bill because of the licensing and the municipalities being able to oversee, they can, all that. So I don't think we want to put liability where liability is not where it needs to be. And if you have a licensed engineer and architect that's doing an inspection, that should fall under their license. If something was to happen, that should fall on that inspector. It should not fall under our municipalities. Our municipalities will do a final, absolutely, to give a certificate of occupancy. And if they see any discrepancies, that's where the builder has to make those corrections, whether that going back to those inspectors or going back to their own engineers and redrawing something or have to redo something. So that end inspection does fall onto the municipality, but I don't want to put every single inspection that third party, party would do an inspection on the municipality. That should be on them because they're the ones that are doing those inspections. Keep the liability where it lies.
Representative Lucas.
Thank you, Mr. Chairman. Representative Filer, I'm not a contractor, never have been one, but I've done a number of construction loans over the years, and I'm relatively familiar with this concept. And also in other industries, licensed professionals are required to do certain jobs. Home appraiser is one. And I am not really I'm wondering what you think of a government putting together a list of recommended inspectors. I have seen where the government agency or the city will put together a list of licensed individuals, but with no recommendation one way or the other. And I'm wondering then, what do you think of that? And if you were to have somebody be responsible for determining whether or not an inspector should be preferred or not, or recommended or not, should that not lie with the contractor? I'm just testing for understanding. Thank you.
Representative?
Mr. Chairman and Representative Lucas, you're right. There's, as a matter of fact, in most building departments right now, if say you need a water study, I mean, just throwing something out, they will have a list. These are licensed contractors, but they do not give recommendations. The municipality should never give a recommendation on who to do any work. That is not in their purview, but they can't say, here's our list of licensed, contractors that do inspections. This is their, they qualify, they have their license. They can probably submit that list to you and let the contractor decide who they want to hire. But yeah, we definitely don't want the municipalities saying, well, we like this guy over this guy, or vice versa. We don't, that's definitely muddying the waters there. We definitely don't need municipalities doing that.
Any other questions? I just had one. This covers both commercial and residential, correct?
Mr. Chairman, that would be correct. Yes.
Thank you. All right. Senator Love, I see you're on this too. Would you have any other comments or care to answer questions?
Mr. Chairman, thank you, through you. Yeah, so as I listen to the conversation on this, I am a co-sponsor on this bill. I'm also a builder in Laramie County. And so when you first call, so you go dig your hole to build a residence, your first conversation then is with your engineer, and your engineer is required by the county to come inspect that open hole because they're the one certifying the foundation on it. And they have to make sure it's set on virgin soil, that there's no recompacted soil in there. And so this is not an unfamiliar process to our county already. I did hear Mr. Filer say, though, that you couldn't use the same one that was in the licensure, but it's incumbent upon that engineer to inspect his own foundation, his own work. And so when you're talking about the engineer that did the actual work, I think for his license, he would need to have access to and be able to inspect those properties in order to make sure his foundation set on virgin soil, which is the open hole. It's the very first inspection done on any project. And so the open hole inspection shows up, your engineer comes out, they make sure you're setting your foundation where it's supposed to be. And then they report that electronically to the county, and that becomes your first inspection. So this is not an unfamiliar process. I do think, though, we probably ought to make sure we work on the wording so we're not excluding that engineer from his project, because he is the licensed engineer on the project and is accepting all liability therefore. So we need to be real cautious of that.
Questions? Yes, Representative Webb.
And it's more of a general question. Thank you, Mr. Chairman. What do other states do? Is there any practice in other states that we need to look at?
Senator?
Yes, there are. Other states do allow for third-party inspectors to come through. They usually have a list at your local municipality or county of inspectors that they trust and are licensed engineers or architects and meet that of local and state codes. And then they can come do those inspections. It's electronically reported to the municipality or the county. And what it does is it helps lighten the load on our municipalities and our counties. When it gets really busy, it can get really tough to get things done and keep up. And they have a lot of plan review to do. They have a lot of studies to make sure they're checking. They had a lot of other things to do besides just run around and look at every project. And so if this is one way we can alleviate some of that stress for the municipalities and the counties, I think that's a great way to do it. It needs to be done in conjunction with them, though. And there needs to be a relationship built between them and whoever the third party inspectors are.
And I'm assuming that because we've all been involved in some projects that might go bad. I'm assuming that each town or city or county will have that sign off along the way in their own rules or their own way of doing things that accounts for a liability along the way, because you hate to have a project in the end where everybody's pointing fingers at each other and it ends up in a nightmare. So I'm assuming that you mentioned it already, that accounts for that with the city's own codes and own processes, and doesn't necessarily need to be spelled out into law.
Mr. Chairman, that is correct. Actually, the bill allows for that for the local authority to make sure and do those audits also. So it allows for those municipalities to do that.
All right.
Yep.
Any other questions? All right. Thank you. Next, we'll have up any agencies. And then I'd also like any city, towns, or counties that would like to speak to this. Any building departments or planning? Welcome. I'm getting to see everybody twice today. Yeah, exactly. Go ahead and state your name for the record and
Thank you
then
very
your
much.
comments.
Am I on? Am I on? Yep, I'm on. Just quiet. I'm always quiet. Mayor Juarez, City of Mills. I appreciate Chairman and the committee for having us today. Across the board, I am in support of streamlining as much as we can to develop homes and get it out there and moving fast. I do think this is a good idea, and I think we should work to move forward on it. But I do have some questions, and I think some of you have actually posed those. Specifically related to some areas that don't have building inspectors and have to rely on the state's office to do this. So this is a great proposal to resolve some of that. My concerns, however, though, the city of Mills oversees the town of Bar None, so that's our jurisdiction. We got that unique approval from the Wyoming Fire Marshal's Department to oversee their building inspections. So there's some concern there if an engineer is allowed to inspect and it's our jurisdiction and our liability when it becomes through wrong, what does that do to the municipality that's liable for those inspections? I think that the proposal that the inspector have a personal insurance policy is a little bit concerning. I think we've all known of builders to build homes and then they're gone and then we've got problems. There's situations across the state. So how do we hold those individuals accountable if they've caused damage or harm to homeowners? I think the biggest part, though, is that the third party should be ICC certified, just the same as our inspectors, and that's a standard set by the Wyoming Fire Marshal's Department. But I would like to point out, though, that in traditional form, when our building department or building developers come through, it's the engineers involved, in the designing and all of that. I think that it's a conflict if that same person's also inspecting their own work. Traditionally in that process, if somebody does engineer or design, it's another firm that reviews their plans or their plot to make sure that it's compliant. So there's probably some conflict there on that one. But those are my main concerns with those bills. But I do want to move forward to see that we get some additional help for inspections. For that, I would stand with questions. Thank you.
All right. Any questions? And I think those are valid concerns. I would hope, whether it's the state fire marshal or local inspection, that is involved in the CO as well. And so I think that would probably cover that. But all right, next. Oh, I'm sorry. Representative Johnson.
Thank you, Chairman Knapp. Long day. Have you talked to your insurance provider? I mean, I can see a problem if the city of Mills is responsible for the ultimate building of that building, and then the contractor. I think those two insurance companies are going to have to work together. And I don't know that. Have you talked to insurance providers? I can see a problem there. So I just,
Yeah.
Ms. Mayor?
Thank you, Chairman and Representative Johnson. I can only speak to the effect of it's very frustrating, the current insurance situation that we are in and the often denials that they send to us. So I would imagine in this aspect, they would deny covering and the city would be responsible for paying, which is a whole other discussion for another day.
Thank you. Any follow-up? Any other questions? All right, next. Thank you.
Mr. Chairman, my name is Matt Murdock. I am the mayor of Pinedale and also the president of the Wyoming Association of Municipalities. We have been involved in this bill and working to refine it in a way that it would be acceptable to the town. So we currently stand in a position of support. I think suggestions that third parties investigating and there'd be liability on the town are very difficult because we cannot in any way cover their work. And I'm going to Representative Lucas's point. The town of Pinedale, for example, is initiating a business license system so that we can be a fair representation of any contractors who are operating within our community. We can't show favoritism. If we did, that'd be a lawsuit. But we can at least make certain that if there's somebody on the website or on the business license system that they're certified, have the insurance that's required by the state, et cetera. So that would be the best we could do at that point. And then after that, the other thing that I think that we've been working on and looking at is how to get this process done as quickly as possible. Representative Filer and myself have talked about, we want developers to walk into a community and several things, right? We want a developer to walk into the community and know that there is a shot clock and know that, he has a very reasonable expectation that his permit will be delivered by X number of days. Now, if there is something extraordinary that requires additional engineering that a town has to go out, that shot clock has to be changed, because if I have to hire somebody from Jackson, like the town of Pinedale has 2 people that work in our planning and zoning department, and if there's something special to come up, we have to get another engineer to come in and look at it because we just may not have the expertise. So elements like that are covered within the bill, they're protected. And then we are moving more towards like a digitalization of our entire permitting process so that will go faster. And what we've designed at this point in time is it will actually save us almost the equivalent of 1 full-time employee. So by having that opportunity there, it gives us the ability, a transparency. You put your application in, you know where you are in that application. If you're missing something, you'll be notified of it, which is one of the major problems. When applicants come in, they think their package is turned in and there's a piece missing and somebody's scrambling because there's another meeting or another project, and we didn't tell you until the last minute that you forgot, attachment A of your document. So this system will do that. So it is complicated, and with towns that have small staffs, it is a big burden. And there are projects that come into our communities of 2,000 that are really a 10 or a $20 million project that are far beyond the skills of my own staff. So I think that is extremely important that we always have allowed for that. And I think that is represented within the bill. I think those are my only comments, Mayor Juarez made the other points, and I'll just pause there if you have any questions.
Yes, Representative Webb.
Thank you, Mr. Chairman. Thanks, Mr. Murdock, for coming today. Same question about what other states do. Has WAM done any research? Could you provide us with research states that do, don't, just that type of information, please?
Mr. Mayor.
Through you, Mr. Chairman, to Representative Webb, I personally don't have any knowledge. I mean, I have experience of working a project and having the shot clock reset for the wrong reason. So as I have the experience on the developer side of being in other states and being frustrated, what I've heard from our developers say, but I don't have specific representative laws that are pertaining to this exact ordinance. I do know that we have had conversations with other cities that are trying to more of a digitalization process. And that's kind of where we've leaned in as a town and where WAM is leaning into, but I don't have any specific statutes that I could reference you to.
As you've circulated this through WAM, have you had any pushback from any cities, towns, or?
I mean, I think to be fair, Mr. Chairman, the greatest concern is that you are setting up a system that could create it so that a town that has a very small staff, and Pinedale has 2 people, that's pretty good. To be really frank, we're not Cheyenne, we're not Laramie, we're not Casper. I have 2 people who are really talented and they work far more than 40 hours a week. But there are other towns that have one person or no person. And as long as this bill gives us that exit, so that if there's an instance where those people can say, raise their hand and say, we're beyond it, or I have to hire a third party to move in here, that's fine. But if that shot clock pertains to some small towns, there is concern that could be out. But we've talked it through our committee. We've worked very hard with the writers of the authors of the bill to make certain that we as WAM, and that's the other thing, that we as WAM are working towards an overall digitalization for all our communities. Some of you might have seen those requests. We're hoping for an appropriation so that all our code could be digitalized. If we could do that this year, that would give every community the ability to have a system very similar to what Pinedale has, where you can go in, make your application and track it. But it is an expense, but it is a savings.
Thank you. Any other questions? Thank you very much, Mr. Mayor. Next.
Mr. Chairman, members of the committee, my name is Ashley Harpstreet, Executive Director for Wyoming Association of Municipalities. I don't really have too much to add except for we've been working really hard with the sponsor on some other bills to expedite the process and the permitting process. But this one we didn't really get to look at till February 10th. And with the amount of bills that have come at us, and as you guys are facing the same challenge of sorting through it all, we actually, I hate to correct my president, but we have a position of monitor on this bill. And conceptually, we support the idea for the reasons that they just said, but there's just still a lot of details we have to sort through, and would love to work on this to get to, support and get it through, but.
And we won't have you two debate that here. So.
My apologies. I've been going from meeting to meeting as well.
So no,
my apologies.
Mr. Chairman and Representative Webb, no, we don't have much feedback on this yet. My members are here this week and are listening to it and trying to ponder and figure it out. So.
And again, if you do, just please let us know
Absolutely.
through email. So.
Yep.
All right. Any other people in the public for this particular issue? Go ahead and introduce yourself for the committee, and we'll have your comments.
Thank you, Mr. Chairman. Appreciate that. My name is James Halverson, serving as the Deputy State Director for Americans for Prosperity. I'll be very brief. We think this is a well-written, well-thought-out bill. We commend the good representative from Cheyenne for doing his homework. We think that this still, keeps in place or puts in place all of the proper safeguards that are needed. Obviously, we want to ensure people are safe in their homes and through that building process. But yet, sometimes, as you've heard, private industry can sometimes move a little bit faster. Maybe they're available more on the weekends or after hours. This will help speed up commerce. It will help encourage more economic development and could possibly likely lessen the burden on our municipalities and our counties. So we are in favor of this bill, and I thank you.
Thank you. Any questions? Thank you very much. All right. Any other folks have anything on this bill? Is there anybody online?
No, Mr. Chairman.
All right, I'll close public testimony on the bill. Committee, what's your pleasure? Yes, Representative Johnson. Quickly, if you have a quick question.
I really got a concern about this and the insurance policies and the confusion between the city and the contractor pointing to a failure of the project. And I would hope that maybe, I know we're limited on time, but if you could maybe write some sort of amendment to this that we could see on the floor. I'm really concerned that we're gonna have two people pointing fingers at each other and say, it's not my fault. And I would like to have some way to, that somebody's absolutely responsible. And,
Representative.
Chairman, Representative Johnson, I would like you to look on page 6, if we could. On paragraph I, starting on 12. A third-party inspector who is an architect licensed under Title 33, Chapter 4 of the Wyoming statutes, or a professional engineer licensed under Title 33, Chapter 29 of the Wyoming statutes, shall maintain professional liability insurance in an amount of not less than $1 million per claim. If this engineer does an inspection, it's on them. It's not on the municipality. I totally understand, like, if the municipality goes out and says, well, we don't think that's right, that's your fault, or vice versa, or whatever it might be. I'm just trying to think of how, because municipalities are already insured, they're self-insured, how that works. If a building inspector goes out and inspects something and it falls down and they signed off on it, that's on the municipality, that's on that building inspector. I want to make sure that if we're using a third party because it's not a municipality or a government entity, there has to be something where somebody can write a claim because it's on them. And this is actually defined by our statutes, what it is now, if you have that engineer license. So I'm trying to think, I think instead of insurance, maybe more of assurance, that we need assurance that they're not going to blame each other. There has to be something in there. Or something like that. But the insurance amounts are already set by statute.
And when it comes to litigation, I don't think there's any statute you can write that's going to solve everything. So, all right, I'm going to close public testimony. We do have another bill still to move on to. So is there, okay, thank you. Second? It's been moved and seconded for moving the bill. Are there any amendments to the bill? All right, seeing none. Did you have one? Okay. All right, seeing none, we'll go back to the bill. Any discussion? Discussion? All right. Yes, Representative Weber.
Thank you, Mr. Chairman. I like the conversation that I'm hearing here about this, and I think there's a lot of people that could be helped by it. I know in the area that I'm from, we currently have a situation and it's in a lawsuit because of one builder said they did this, the other person said they didn't, and it's in a lawsuit. So the building was built and we still have a building that, yes, there are some people that's occupied, but it's causing a lot of problem for at least the people paying for the attorneys. That is a big concern. Thank you.
All right. Yes, Representative Webb.
Thank you, Mr. Chairman. And just for discussion's point, I'm not settled with this. I think there's a lot of unanswered questions, and so I will probably be a no.
Representative Johnson, do you have comment?
I have the same concerns and I think I'm going to be a no. I would love to, I like the concept of it. It's just not ready yet though. Thank you.
All right, Representative Brown.
I agree. I don't have a problem with the concept. We're talking about $1 million worth of coverage. Many projects, the cost of the project is far beyond that. And so, and the liability could be far beyond that. So I think there needs to be some more work on this.
All right, any other comments or discussion? Seeing none, please poll the committee.
Mr. Chairman, this is a roll call vote for House Bill 140. Representative Brown,
No.
Representative Locke,
Aye.
Representative Heft,
Aye.
Representative Johnson,
No.
Representative Lucas,
Aye.
Representative Webb,
No.
Representative Weber,
No.
Representative Yin,
Aye.
Chairman Knapp.
Aye.
Mr. Chairman, you have 5 aye, 4 no.
Okay.
That was 5-4, you said?
5 aye, 4 no, Mr.
Okay.
Chairman.
That bill does carry. Maybe we can address some of those concerns as we go forward in the process. The next bill up is House Bill 144, Fire Protection Districts, Mill Levies Amendments. And we have Representative Campbell. Welcome.
Good afternoon. Me here fine? Yeah, Mr. Chairman.
Yeah,
Thank
ready.
you, committee. Thank you. My name is Elisa Campbell, representative for House District 56. Before I start, if I may, Mr. Chairman.
Yes.
Just appreciate, we have our Laramie County Fire Protection District here and our Natrona County Fire Protection District here. So thank you to them for coming over, especially my guys from Natrona County. Thanks for driving down. So as all of us know, we rely heavily on our special districts, especially our fire protection district. They are the ones that are first on the scene for all hazardous incidents, and not only are responsible for the unincorporated areas of our counties, but also provide critical support to the incorporated areas, all of our municipalities. And what we are seeing, as we know, oftentimes decisions made at the state affect revenue streams locally. So many of our fire protection districts are struggling right now. I know in Natrona County, because of revenue streams and lack thereof, reducing in staffing, which then relates to, and I'll let these guys answer those questions, pretty consistent brownouts, or we don't have coverage, or may have to shut down one of our stations. This creates challenges throughout the county. So how do we best equip our counties with maybe the ability to remedy that, and shift some of that authority to them? So this is the creation, or why I bring you House Bill 144. It really is pretty simple. What we are doing is just adjusting the authority and the cap within which our counties have the ability to raise revenue for our special fire protection districts. So as you will see on page 1, we are just amending Wyoming Statute 359203 and then Wyoming Statute 3913-104. So you will see this on page 2 and page 3 as we adjust those two. It really is just the state adjusting the cap that our counties have to work within. So right now, that cap is set at 3 mills. You will see that on page 2, line 7, and then again on page 3, line 4. The not to exceed cap was 3. I realize you're probably looking at the draft in front of you where it says 10 mills and are thinking, what are you doing? This is a really bad idea. Most counties, I mean, overall, a cap is 12. I will be completely candid with you. That is my fault for just putting in a placeholder because I didn't know what that number would look like. So after conversations with our counties, our cities, our just getting more information, I would strongly encourage this committee. One of the first amendments would be to adjust that to 5. That seems to be reasonable and acceptable not only from the district side, our fire protection districts, our counties, our municipalities. Consensus seems to be 10 is the way to go. So that would be my strong recommendation. And those are the only 2 adjustments, would be adjusting that cap. So taking it from 3 to 5 and then giving our counties the ability, the authority to adjust and make those decisions locally as to how they might better fund their fire protection districts.
All right. So as chairman, I'm going to try to manage this. We have 15 minutes before we're back on the floor. So let's keep our questions brief. And for the members of the public that are here to comment, we'll also keep it brief. We'll have to go through the chain of command maybe and have some people speak. But I do appreciate everybody being here. I was county commissioner for 12 years, served on the fire board for 12 years. So I appreciate how much an engine costs, how much staffing costs, and certainly appreciate the service that you all provide. So with that, questions? Yes, Representative Johnson.
Thank you, Chairman Knapp. Representative Campbell, I'm all for local control. What would happen if we didn't raise the mill levy, but allowed you to bond for 3 years? And so that every district would be able to raise the money necessary to keep their district going and that would be up to local control then. It wouldn't be just a blanket waiver. I would be more comfortable with that because every district is different. And that would give the people the chance to, and maybe we could amend that to that part.
Representative Campbell.
Mr. Chairman, through you, Representative Johnson, thank you for the question. I don't know that answer. I am quite certain though that there are people behind us that could far better answer that question than I could.
Follow up? Other questions? All right, thank you. All right. Do we have, if you have another representative, are you here to answer questions on this as too as well? Representative Lean.
Thank you, Mr. Chairman. To be brief, I just wanted to touch on the multifaceted dynamic that's happening in our area is that there's many things going on, but this is one quick way for us to be able to solve the staffing problem. And why that's important, my district is 88% rural, and all of the folks that are 10 miles from an incorporated municipality stand to lose their homeowners insurance if we can't staff our county fire adequately. Their ISO ratings are going up, making homeowners insurance either unavailable or outrageously expensive. And so I ask you to consider, I agree with the 5 mills to the committee's discretion. I just ask for an aye vote today.
Appreciate it. Any questions for Representative Lean? Thank you very much. All right, any other people to testify on this? Cities, counties, townies, fire departments? All right, and we are down to 2:17. We'll give each person roughly 2 minutes. And then again, limited questions, but feel free. Thank you. Go ahead.
Mayor Juarez with Mills, I'll do it my best to do 2 minutes. I wanted, thank you, Chairman and the committee. I wanted to touch on the bond issue. The problem we have right now is the consistent revenue stream, so a bond wouldn't specifically help. I fully support what Representative Lean said. She's spot on with all of that. So my only talking point for this will be the fact that some of the problem here has to do with the ISC demands from the judge awards. So the guys were demanded to pick up over $2 million in vehicles and equipment for ISC projects that have yet to pay and probably won't be started. So that's a legal obligation that they had to fund. So that the shortfall there is also on ISC, which is why this makes this specific fire districts different than all the other districts. They have those unique demands upon them that most other districts don't have in that regard. And for that, I'll stop. Thank you.
Thank you. Go ahead, please proceed.
Chairman, committee, my name is Ryan Grigg. I'm an engineer with the Natrona County Fire Protection District. And the recent decrease in funding has made our issue in Natrona County worse. Natrona County is no stranger to budget shortfalls. What that means for us is it means we are closing down stations. Our East Side station has been browned out, which means we don't have the staffing to cover that for those days. 30 times in 2025. Those residents on the east side of Natrona County and the northern edge of Natrona County went without services those days. We consistently respond to structure fires with 2 people. That is significantly lower than what the NFPA recommends. They recommend 4. We do it with 2, and we do that on a consistent basis. Wildland fires are the same. We responded to over 100 wildland fires in Natrona County last year. And when we do that, we don't have the backfill to maintain those stations. So when we're on wildland fires, any call that comes in our area typically either gets passed down to our neighbors or goes unanswered. An increase in funding will significantly help that. And we also support the increase to 5 mills. Thank you, Chairman, and thank you, committee.
Thank you very much for your testimony. Yes, please go ahead, introduce yourself and give us your comments.
Mr. Chairman, through you, and members of the committee, my name is Manuel Muskis. I serve as the Deputy Chief for Laramie County Fire Authority here in Cheyenne, where I've served the community for over 25 years. I'm here in strong support of House Bill 144, even with the 5 mills. As you know, the current 3 mill cap on fire districts was established in 1947. That was over 80 years ago. And I believe someone spoke of the cost of fire apparatus today, a fire engine's over $1 million. With the reductions in tax we've already received, our district alone is looking at over a 35 to 40% decrease in our budget. So stand here. I know I'm trying to keep it really short in support of House Bill 144, even at the 5 mills.
Thank you, Deputy Chief. Yes. County Commissioners Association.
Good afternoon, Mr. Chairman, members of the committee. I'm Jeremiah Riemann here on behalf of the county commissioners across the state. I hate to be the guy that provides a different perspective. I'm really supportive of our fire community, and as you all know, I've been the guy sitting up here saying we have to be really thoughtful about the property tax reform that we're doing. I have to be, I have to stand before you in opposition to this particular bill for a variety of reasons. First off, appreciate that there's some consideration of looking at something other than 10 mills. For context, 10 mills is almost as many mills as the counties can assess, and so that really causes a great deal of concern for the commissioners. Second, it's my members that are ultimately the ones that have to sign on the dotted line to assess that mill levy. And guess who's the first one to hear from local constituents when they're a little frustrated about what that mill levy looks like? So I do ask you to be thoughtful about it. Going to 5 is better than 10. But not necessarily to the point of gaining our support. I'll also say that fire districts are not the only entities that are feeling the compression from the property tax reform. There are weed and pest districts and other important special districts across the state, as well as counties and municipalities that are feeling the true pain of this. So I do think we have to be really considerate about what we do and be deliberate about it. But right now, this is not legislation that we can support. I also do want to call to your attention to look at whether, I know that it's been suggested that this is voter approved. I'm not quite certain that that's the case. It's certainly voter approved to form the district, but the change in the mill levy is not necessarily for every special district. And I've dug on these ones. I can't find where there is a voter component if they are to change those mill levies. So be thoughtful about that as you move forward. And with that, Mr. Chairman, I would sit for any questions.
Thank you. And we will have you have a security escort out of the room as well. All right. Are there any questions?
Yes, I have a
Yes, Representative Weber.
Thank you, Mr. Chairman. Thank you, commissioners, for being here, and fire chiefs. I have a question for you about if a special district is allowed, this special district is allowed the 5 mil, do you anticipate all of the other special districts in the county coming and asking for the same thing?
Yeah, Mr. Chairman.
Yes. I'm sorry, Mr. Nyman.
Yeah. Mr. Chairman, Representative Weber, first off, in terms of the counties couldn't ask without a constitutional amendment. We are limited through the Constitution to 12 mills. Yeah, I would suspect if you move this forward, there are a lot of other special districts that might want to see their adjustments or see adjustments to their mill rate because this is a way to alleviate the compression that was created through the property tax reforms that have been undertaken.
Follow up.
Thank you, Mr. Chairman. It seems to me that, 5 mil is quite a bit compared to the whole county budget that the county commissioners have to adjust and monitor right now. Seems quite a bit. I don't have the answer. I don't have the answer either. Maybe a study. I'm not sure. Thank you.
Any response?
Yeah, Mr. Chairman, I don't know that I have any better answer other than to look at some, thoughtful reforms. You've got a couple of different bills that are working through the process. Senate File 110 is a good example where it could provide relief and ultimately provide a little bit of lift and relief from the compression that the fire districts, the counties, and others have experienced.
Thank you. Yes, Representative Johnson.
Thank you, Chairman Knapp. I'm kind of torn on this, and I know it's an emergency here. We're going to lose the insurance, on homes. And I would like to offer an amendment that there's a sunset in July 1st of 2030 and give us 4 years to figure out a better product. I still think that maybe the bonding issue that would have to be voted on, every district could vote on their own bond issues, and the homeowners the citizens would vote on their own tax increases that way. So I would offer that amendment if that's acceptable to the bringer.
All right, any other questions? Thank you very much for testifying. We appreciate you being here as well as everybody else. So is there anybody else in the room that has testimony quickly? Yes, please identify yourself.
Thank you, Mr. Chairman. I'll be very quick. Ryan McConaughey with the Petroleum Association. I couldn't leave Jeremiah on his own. Our big concern here, of course, we agree that something needs to be done for fire protection districts. As you all know, most of these districts are often drawn around development of our mineral industry because they are who pay the taxes. And so we just have concerns, especially at 10 mills. And so we would certainly support the 5 mil amendment and agree that there are probably some other solutions that would be helpful beyond putting these additional mills on the mineral industry.
right.
And happily answer any questions, Mr.
Thank you for industry from your testimony. Any other questions? All right, please go ahead.
Thank you, Mr. Chairman. Brett Moline, Wyoming Farm Bureau Federation. Not to quibble about what the increase would be, if it's 10 mills or 5 mills, what we would ask is that instead of the county commissioners being able to do that, that would go up to the electors of that district. I will point out on page 2, line 9 through 12, that no limit on the assessment for payments of principal and interest on bonds approved by the board of and the electors of the districts. So a bond has to be voted in by the electors, but the operating, currently the 3 mills can be done by the commissioners. What my organization, strong policy supporting fire protection, the fire departments, but we also have that any change in taxes, any increase in taxes, especially property tax, should be voted in by the people. I hope I made myself clear, sir.
So would you support both the commissioners approving and a bond by the electors?
Mr. Chairman, what I would support is currently the bonds have to be voted in by the electors. The 3 mills, currently what is 3 mills proposed be moved to 5 can be done by just the county commissioners, does
Right.
not require a vote of the electors. What my organization would support is a vote on the 3 or 5 mills done by the electors, not just signed in by the county commissioners.
All right, thank you. Any other questions? All right, well, that's it for the people in the room. Is there anybody online?
No, Mr. Chairman.
All right, thank you very much. I will close public testimony for, did you have a quick question?
Thank you, Mr. Chairman. I'm just, I guess, again, testing for understanding, but it kind of sounded like the county commissioners, do they have this within their own power to raise the mills to 5? Or is this something that is a state mandated,
Their current limit is the 3,
is the 3, and that's law?
as far as I know.
Okay.
Yes, correct.
Thank you.
All right. I'm going to close public testimony at this point. Committee, what's your pleasure?
I would like to offer.
Okay, it's been moved. Is there a second? It's been moved and seconded. Are there any amendments? Yes, Representative Locke.
Mr. Chairman, I would move that we change the 10 to 4 in both cases. And let me give a perspective on that, just so everybody understands. Is that okay?
I would say yes. Would you also deal yes or no with the electorate question?
Yes, I would like to deal with that, as part of the proposed amendment, or I would like to deal with it, make sure that to make that change, election of the people is required.
All right.
Would you like me to wait to explain?
No, go ahead and explain.
And just real quickly, let me give a perspective on what 1 mill.
Mr. Chairman, can someone else second that then? Because I was only seconding the reduction, but. if someone
Okay,
would
yes.
please
Is there a second to that amendment?
Sorry.
Okay, it's been moved and seconded. Discussion on the amendment. Thank you, Minority Leader Ian.
Let me give a perspective on my proposal of 4 mills. 4 mills is actually an increase of 33.33%. to the income of this particular income stream, just to give a perspective. And it's actually potentially quite larger than that when you look at it, because depending on what the property tax covers, well, I should say it's larger than that. What I should say is a lot of the impacts to the budget have been in the residential revenue stream, and I do understand that. And I'm considerate of that. That being said, that 1% now is applied to if your revenue stream is across a broader set of property taxes. Again, it applies to that entire stream. So I wanted to at least put it in perspective why I viewed 4 as a reasonable response to at least some of the recent requests. But as all of you in the room and everybody here at the table knows, that will be debated on the floor. So just wanted at least people to understand the perspective that I had. Thank you.
Vice Chairman Locke, thank you. Is there any other discussion on the amendment? Okay, all those in favor of the amendment, please signify by saying aye. Aye. All those opposed, no. All right, that amendment does carry. Are there any other amendments? Yes, Representative Johnson.
Thank you, Chairman Knapp. I would like to propose that a sunset date of July 1st of 2030, give 4 years. And that way you would have 4 years of the residents screaming or howling or wanting to change it or possibly doing something else. But they could also have the possibility of allowing it to bond out and set their own tax rate.
Okay, is there a second to that amendment for the sunset date? It's been moved and seconded that the sunset date be moved to, or be added to July 1st, 2030. All those discussion.
Mr. Chairman, yeah, so adding a sunset date actually makes it more complicated, especially because there would be an election involved. So at the max, let's say they get it on a ballot this year, it's in November. And then they get it starting in 2027. You get 2.5 years. And when it's put on the ballot, does it say that it's going to sunset in the ballot? And then if we change that, will it actually sunset or they have to do another election? I think a sunset just makes it way more complicated, especially if we're putting it on the ballot. And it becomes a kind of shortened time frame, because if they don't get on the ballot this year, the next time they'd be able to get on the ballot would be in 2 years. And then they only get 1 year. So all of that to say, I'm going to vote no.
Unreliable stream of income there. Any other discussion on that amendment? Representative Johnson.
Let me withdraw that amendment and allow allow this for 2 years. And that, I'm trying to think, Representative Conley had a bill that would, you would vote on it every 2 years.
I think if you're just withdrawing that amendment,
Yeah.
if you'd like to
Yeah,
add
I would
a
like
new amendment, we can do that. Otherwise,
I would
we'll,
like to withdraw that amendment.
all right. Second concurs. That's withdrawn. Any other amendments? Seeing none, please pull the committee.
Mr. Chairman, this is a roll call vote on House Bill 144 as amended. Representative Brown,
Aye.
Representative Locke,
Aye.
Representative Heft, Representative Johnson, Representative Lucas, Representative Webb,
Aye.
Representative Weber, Representative Yin.
Aye.
Chairman Knapp.
Aye.
Mr. Chairman, that's 8 aye, 1 no.
All right. That committee bill does move forward. Seeing that, that's our agenda for today. Thank you very much for coming. We appreciate the testimony. This meeting's adjourned. Good. I think that'll help.
Think your stuff. You think you're right. Yeah, it's a very important.
Oh, yeah.
We need to thread this needle a little bit. We're not trying to cut the smoke, but we've got to figure it out. I'm actually crossing my fingers.
Hey, how you doing? I didn't see you out there.
You want this inside?
Was it you that mentioned?
Okay, sounds good. Good to see you. Thanks for coming down.
Hey,